Has the state disclosed all items of physical evidence in discovery, Ms. Schneider?
Yes, we have, Your Honor.
And has the defense reviewed the discovery in this case with your client?
I have, Judge.
And is either the party aware of any physical evidence, if tested, that may exonerate the defendant of the charge or charges in this case?
No, ma'am.
State? You're not aware of any evidence that would exonerate him?
Your Honor, that would exonerate the defendant.
Okay, thank you. All right, Mr. Cruz, at this time, do you have any questions, either for me or for your lawyers? If you need to speak to your lawyers, I'm happy to give you time in private so that you can talk to them. I'm about to ask you how you wish to plea in this matter, and then there won't be any time for questions. So now is the chance. If you have any questions for me or your lawyers, just let me know.
I think I'm good.
Okay, you sure?
Yes, ma'am.
All right. Sir, in case number 18-14129, to count one of the information, attempted aggravated battery on a law enforcement officer with a deadly weapon, how do you wish to plead?
I plead guilty.
Count 2, battery on a law enforcement officer, how do you wish to plead?
Guilty.
Count 3, depriving an officer means of protection, how do you wish to plead?
Guilty.
And count 4, attempted use of self-defense weapon against a law enforcement officer, how do you wish to plead, sir?
Guilty.
Also, are you agreeing that your credit for time served at this point is 1,068 days?
Yes, ma'am.
Okay. I accept your plea of guilty. I find that you are alert and intelligent, that you understand the nature of the charges, that you understand the consequences of entering into the plea. I find that you have made an informed decision with the advice of counsel, and that you're knowingly, voluntarily, and intelligently waiving all of the rights that I just went over. Are the parties stipulating to a factual basis for purposes of the plea in this case?
Yes, Judge.
Your Honor, the state is prepared to prove by competent evidence that on November 13th of 2018, the defendant attacked Sergeant Ray Beltran, who is in the courtroom today. Sergeant Beltran was wearing full BSO gear and was in fact working at the jail, so the defendant was quite aware that he was a law enforcement officer. The defendant proceeded to kick, hit, punch Sergeant Beltran, attempted to remove Sergeant Beltran's electric taser, took that electric taser and attempted to hit Sergeant Beltran with it over the head as if it was a blunt object, and attempted to remove that from his person, thus giving a basis for all of the charges.
Okay, based upon the proffer supplied by the state,
Judge, we would stipulate as the facts as alleged in the PC.
Okay, the stipulation by the defense counsel, as well as my own review of the court file and my review of the video that was presented to me at a court hearing, I do find there's a factual basis for the plea. And
Your Honor, I'm just going to interrupt for a second because for some reason the printout that I gave you of the score sheet did not include the last charge, so I've added it. It makes all of a point of difference, but I would ask that we use the corrected score sheet.
did you give Mr. Wheeler a copy?
I will in a second. Let me add the
You
point.
sure it's not there? The point
No.
two?
It's not synced.
It's this one.
Maybe I did here.
Do you have a supplemental page?
No.
Your point two. Yeah, there's a point two.
There's a point to, but it wasn't listed, so I've listed it now.
So have you seen the corrected score sheet?
Yeah, I saw it when she handed it to you, Judge. It's fine.
Do you want to take a look at it?
Judge, it appears to be the same calculation. They just looked off the charge.
Okay. But the ultimate calculation is by... It looks like he scored what I told him was 14.40 at the bottom, and now it's 14.41.
That's fine.
Okay, do you understand, Mr. Cruz?
Yeah, I understand.
I advised you that the bottom, what we refer to as the bottom of the guidelines, or the lowest permissible prison sentence under the Florida Criminal Punishment Code, was 14.40 months Florida State Prison. The state inadvertently left off the use of a self-defense weapon, which is a first-degree misdemeanor. When you add that misdemeanor, which is a .2, you come up with the lowest permissible prison sentence in months of 14.41, as opposed to what I told you, 14.40. Do you understand?
Yeah, I understand.
Does that change your decision as to whether to enter into this plea today?
Nope.
Okay. And is Mr. Cruz requesting a PSI?
We are not, Judge.
So you're waiving PSI?
Yes, ma'am.
Okay, and when are you all requesting to set the second case for a plea?
Wednesday, Judge, next week.
And does that date suit the state?
Yeah, that's fine, Your Honor.
So we'll do it Wednesday at 9 a.m.?
That's fine.